It is a remarkable and infuriating fact to me that the Tea Party and the Republican right has basically claimed ownership of the Constitution. As someone who's spent most of his life thinking and writing about these men who created the Constitution, the Constitution does belong to all of us, and I think in particular it belongs to progressive Americans, and I hope we can make some progress in taking back the Constitution from a small cult within our society. So what were these framers of the Constitution about when they set out doing this? I have to say, having spent a lot of time with these folks, I'm wary about making pronouncements about either their original intent or their original meaning, even though to us, 224 years after the fact, they look all pretty similar, like a bunch of dead, wealthy white men. In fact, there was an enormous diversity of views among them. It was often a contentious gathering over those nearly 4 months in Philadelphia. So I'm not inclined to make pronouncement about how they would have interpreted the Commerce Clause or the President's war powers. But in terms of their overall intent, the driving impulse that brought them together and sustained them through that summer, I come to a very commonplace answer, which has been evoked by John Podesta in his Politico column yesterday, by Tom Daschle in his remarks last night, and by the reading of the preamble. This Constitution really was formed to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, which is a very significant responsibility. And you don't do this with a Constitution which essentially consists of the Second Amendment and the 10th Amendment, which is the Republican reading of the Constitution today.
Roosevelt believed what Robert Jackson, who was later his Attorney General and later his Supreme Court Justice, said, which is that the Constitution contemplates a really effective government. The American experiment is supposed to succeed, and the national government is supposed to have the powers that it takes to perpetuate the nation. This is something that the founders saw, this is something that Lincoln saw, and this is certainly something that Roosevelt saw. Now, I mentioned the confidence of Roosevelt, and we're all familiar with his posture and his tone of voice and the confidence that he projected on just about, on really every question publicly. As I indicated, that really did extend to the Constitution, and this wasn't just sort of a vague, wishful kind of confidence. He had studied the Constitution, he was in constant conversation about the Constitution with his advisors, and he really believed what he articulated in many, many speeches. I'm just going to quote a couple of lines from his 1937 State of the Union address, which I think have particular relevance right now. This was, I should say, the applause line in the speech. There were a lot of great lines, as there always were in Roosevelt speeches. This is the one that got the Democrats in the joint session on their feet. He said, "The vital need today is not an alteration of our fundamental law, but an increasingly enlightened view with reference to it. Difficulties have grown out of its interpretation, but rightly considered it can be used as an instrument of progress and not as a device for prevention of action." That was the debate that threatened to consume his presidency in the first term. That was the debate that helped to define the New Deal, and that was the debate that ultimately got resolved within the Supreme Court in 1937. But I think the critical thing, and if this is of interest, we can come back to this idea. I think if we are going to have any success with an argument like this, in this moment, if we are going to have any success in convincing anyone of what Andrew said as he set up our discussion here today, that these values, these enduring values, indeed undergird what it is that we're trying to do in this moment. This is an argument that we have to make clearly and consistently. We have to hear it from our president, we have to hear it from our other elected officials, and it shouldn't only be heard within conferences like this. And unfortunately, I think that's too often the case, that there's agreement in a group like this, but when we step into the more public sphere, we're not hearing these lines of argument.
You know, what has really happened is that I think, you know, the conversation we're having in the country today about the Affordable Care Act really echoes the conversations that were had in the country about the New Deal itself. And I think one of the reasons why conservatives have had more energy in their constitutional arguments than progressives have is that, they have, in a sense, switched sides in the debate about judicial activism and are now using the Constitution as a club. And anyone who wields a weapon tends to have more energy in that weapon. And so I think one of the challenges that we face is that, in a sense, progressives have been lulled by the success of the last 30, 40 years, and that we are now, in many senses, the judicial conservatives. We are the ones who are trying to live in precedence and trying to live in the accepted norms of constitutional interpretation. And conservatives are, in many ways, the judicial activists. They're forming new theories of limitations on governmental power. The arguments around the Affordable Care Act are new arguments to limit the power of the federal government to solve national problems. They are new doctrines that are being created and adopted many times by lower courts and now some appellate courts. And that we have to be mindful. I think, often as progressives, we sort of stand back and live in our outrage that the people who were attacking us as judicial activists, finding new meaning in the Constitution and new doctrine to challenge arguments, are the ones who are doing that themselves today. And I think the lesson we have to learn, though, is that the Constitution is a powerful document in the minds and imaginations of the American people, and that it has been a struggle for 200 years to capture that Constitution and that sense of who we are as a country, and that we can never rest in our laurels of past success, and that we are constantly doing battle about the meaning of the Constitution, because we are constantly doing battle about the meaning of America itself. And I hope that the Affordable Care Act litigation helps remind progressives that we have to keep fighting.
I admire the founding as much as the next fellow. I've written hundreds of pages on it, but we will want to. One thing that we have to remember that the conservatives don't is the entire constitutional story. So, and I don't think things are that complicated. The more I study the Constitution, the more I'm with Roosevelt. It's actually simple. It's a layman's document. You read, so ordinary farmers could read it and decide whether they were for it or against it. That's what I meant when I said it actually was put to a popular vote. It has to be understood by ordinary people. So I recently posted something on ssrn.com. It's freely downloadable. 6 different arguments for why Obamacare, I'm happy to call it Obamacare, the Affordable Care Act, is easily and obviously constitutional. And 2 of them have nothing to do with the founding of the 6. And I have to be wrong 6 ways, by the way, for someone to believe that this is actually unconstitutional. There are 6 independent arguments, but here are 2, and they have nothing to do with the founding. Let's take the 14th Amendment. Here's its first sentence of the 14th Amendment. All persons born or naturalized in the United States, ... are citizens of the United States. We are all citizens at birth. We are all born citizens. We are all born equal citizens. This is the textualization of Jefferson's idea that we're all born equal. You heard Lincoln invoke that in the Gettysburg Address. We're all born equal. Last sentence. Congress shall have power to enforce this. Here's what this means in the rest of the civilized world. Some people are born with pre-existing conditions. They're not, in fact, born equal. It could have said race. The 15th Amendment says it's about race. 14th Amendment doesn't. It's about all birth inequality. It's a great Enlightenment idea. It's that we're all born equal, whether we're born black or white, or male or female, or I would say gay or straight, or Jew or Gentile, or born first in the family or fourth. There's not supposed to be primogeniture laws in America, born in wedlock or out of wedlock, born with pre-existing conditions or not. And what the Affordable Care Act is nothing less than a human rights law, a civil rights law that Congress shall have power to enforce. And Charles Sumner would have understood this immediately. Okay? And we don't today because we talk too much about the founding and not about these amendments that end Congress shall have power.